SJC-12498, Commonwealth v. Fernando R. Perez.
Ms. Caddick, good morning.
Yes, Chief Justice, may it please the court, Elizabeth Caddick for Fernando Perez. We're here again today because this court had remanded Mr. Perez's case for a Miller hearing. When Mr. Perez entered that Miller hearing, it was presumed that his sentence was unconstitutional, and that presumption was conclusive unless there was proof that there were extraordinary circumstances warranting a sentence worse than had he committed first-degree murder. This court had instructed the motion judge to consider not only the traditional sentencing factors as detailed in Commonwealth versus Costa, but the Miller factors, and this court specifically wrote all of the Miller factors that were to be considered. Now, Mr. Perez, at the hearing, submitted evidence that went to the heart of the Miller factors. In fact, I would argue that Mr. Perez is the poster child for Miller factors. No prior criminal record, no prior behavior problems, was very well behaved in school. Years before this crime, he had been diagnosed with various diagnoses that the research shows makes juveniles more susceptible to crime or the entreaties of others to commit crimes. Post-traumatic stress disorder, ADHD, depression, and he had been deemed, and again, this is years before, he had a psych evaluation at school because he wasn't doing very well in school. And it was found that he was very compliant, walked on eggshells, was easily intimidated. And it was also known that he came from a traumatic background, had a highly violent and sadistic father. The family had moved numerous times, and this was all
And the judge, I mean, when I read your brief, I was, I started to get somewhat persuaded, but the judge wrestles with all of this, honestly. You seem to say he's doing something different, but he actually deals with every one of those factors.
He mentioned them. But
Well,
it's not
more
enough.
than mentions.
It's not enough to mention the Miller factors. He didn't appreciate, and one of the reasons
He struggles
for
with
this
it, doesn't he?
this appeal is the hopes that perhaps the court would instruct trial judges who are used to dealing with traditional sentencing factors and used to dealing with defenses at trial, such as duress, diminished capacity.
But like that point, when I read your brief, you say, well, he's applying the duress factor. He's not applying the Miller.
Right.
But he actually separates out that discussion. He goes, okay, I've done this. Now I'm going to do the Miller factor. So he's honest. I mean, you may disagree with how he balances them, but he seems to be doing what we ask.
Well, I have to respectfully
Okay, go
disagree
ahead.
because what he said was, well, I'm supposed to look at the first Miller factor, which is, the frailties of youth and impetuousness and can't plan ahead. But I find that but the jury rejected his duress defense, and I find that he could have turned the gun on his uncle to not have, gone under his uncle's
Why
influence.
isn't that a valid consideration?
Oh, because it's not an appropriate understanding of a Miller factor. A Miller factor is much more subtle. It's that the pressure by his uncle wasn't, I have a gun to your head and you need to commit this crime. It's that there is a juvenile who is set up and primed to be under the influence of an angry, violent man and who accepts that as normal.
Well, counsel, I understand that puts your client in a very sympathetic position. However, doesn't that also make your client much more dangerous?
No, because he's no longer a juvenile, and he's not, I mean, well, he never had his sentencing hearing, so, in the first appeal, of course, we presented his record in prison, and he has no violence. He was not a violent kid ever.
Can I ask you a question? How would a judge properly apply these factors other than agreeing with you? So if you have these Miller factors, and a judge says, I considered them and I reject them, how, in your view, could a judge properly reject them in a fair hearing?
Well, I think that if you have, say, the family, the influence, like the third Miller factor he rejected, which is his role in the crime and the influence of, a family or peers. And what the judge said was, well, I find that, he was able to function on his own, and he didn't appreciate the influence of not just the early family that left its scars on him, but the uncle who actually was the cause of this crime, who went to his house late at night and immediately said, we're going out to commit this crime, and gave him the gun. And so if there wasn't that instance, for the first crime of this 1/2 hour crime spree, the gun wasn't shown, it wasn't pointed, it was in his waistband for the two Janeses. With the second offense, the boy that he had robbed heard the man and the driver say in an angry voice, hurry up. So we know Perez was not eager to go out and commit this second crime, didn't initially show the gun when the boy refused to give his coat, he showed it. So we have some evidence that this was not someone who was really excited about committing these crimes. If we had instead a defendant who had years of violent crime, who had sanctions by the criminal justice system as a juvenile before, flaunted it, did poorly in DYS, and then an uncle comes along and says, oh, let's escalate it, and I'm going to have you do armed robbery, then that would be a case where the judge would say, oh, I'm considering all this, but I'm rejecting it in this case.
Ms. Caddick, can you tell me if this is, I don't want to recast your argument, but are you saying, well, Judge Ford, he mentioned all the Miller factors, he incorporated them into his sentence and into the circumstances, but that what you don't have is an analysis as to whether or not the Commonwealth burden, whatever that burden might be, demonstrated that there really were extraordinary circumstances that would rebut the presumption of a disproportionate sentence. Is that really?
Right.
That's really
right.
the argument, isn't it? Not just that he touched all the bases.
Right, that there was no proof, that giving lip service to them also pointed out some of the factual inaccuracies that led the court to find that he was, living on his own and independent. He wasn't young when, in fact, he was part of Job Corps in Maine. He was being put up in a dorm by Job Corps, taking diesel mechanics.
But even putting aside maybe circumstances that might not have been precise or using duress instead of applying a
Diminished
specific...
capacity.
Instead of... But putting aside those issues for a moment, the sentencing, whether or not to do a resentencing, is you take all of that and you say, well, are there extraordinary circumstances, and what are the extraordinary circumstances such that the sentence isn't disproportionate, and that there's nowhere in the opinion, and you look at this as, oh, those are the extraordinary circumstances. Right. Isn't that your argument?
That is, and there wasn't proof. For example, at one point, the Commonwealth had argued at the hearing, oh, well, he left Job Corps in Maine because he liked the criminal life with his uncle. And so the judge said, well, The defendant argues that he came back because he was homesick. The Commonwealth says this, and so it's either way. But what the Commonwealth argued was not facts. There were facts in the record, and the facts were that he was homesick, came home from Job Corps, and it was after he came home from Job Corps that the influence of his uncle began, the criminal influence of his uncle. So that's why the second issue is important, the asking for the standard of proof to be clear and convincing evidence. Because we're talking.
But before you do that, that's not what the judge focuses on in terms of the extraordinary. He basically says the only reason the police officer wasn't killed, it was just luck. He was shot at repeatedly. He suffers terribly. So I treat that comparably to a murder. And then we have these two other offenses. And he says, well, I can see giving a time here because we have to respect the different victims. Isn't that what he does at the end? I mean, and, again, I'm not sure you answered Justice Gaziano's question earlier, which I'm troubled by, because you're saying, okay, here you're saying, unless this juvenile had a prior litany of crimes, the judge doesn't really get to consider these factors.
No, I disagree. If there was a crime such where there was a prolonged kidnapping and there was some type of torture or there was some sadism involved or something, the fact that he may not have had a criminal record then would have some
But you're
effect.
essentially saying then the judge on these facts has no discretion, right? Isn't that what you're saying here? That if this person has a 30-minute crime wave, and the judge doesn't get to do the Miller factors, really. I mean,
I'm not saying that. Because this court had said that everything should be waived, both the juvenile, because we're talking about an Article 26 issue, right? His sentence was presumed unconstitutional because when you look at the crime versus the offender, you have to look at it's a juvenile offender.
right, but let me just give you an example. So the judge does focus on the fact that he's got no record.
Yes.
He absolutely says that. And he says, I take that into account. But then he also says his family life was terrible. I take that into account. But doesn't he still get to weigh this stuff? Because he's saying the family life is terrible, but he had a father figure. His first uncle was good. The judge weighs this stuff. I mean, I may not weigh it the same way the judge does, but do we really get to revisit this?
Well, I argue that you do because first of all, in this particular case, that the facts, you have the same facts that the judge had because it was documentary evidence, so you're in as good a position as Judge Ford in looking at the facts. And you should look at the law de novo also because this is a constitutional issue. This is a hearing involving constitutional issues, the Miller factors, and so you always review the law de novo. So in this particular case, you're in as good a position as the judge, and so you can review it. But you can't just say, oh, the outcome of the crime, particularly with Officer D'Amato, was terrible, because this was a case where it wasn't a planned shooting, and he just happened to not die. It demonstrated the impulsiveness and the lack of the ability to weigh the risks and benefits of a crime that a juvenile cannot do. And so when he thought that the officer was going for a gun, he announced I'm an officer and he was reaching, he started shooting wildly, and it was one shot did, unfortunately hit Officer D'Amato. All the other shots hit the buildings, and he was just shooting as he was backing up. And so that shows the young juvenile brain, and so that has to be considered. You can't just look at the outcome.
Doesn't this case sort of reflect that perhaps the Perez 1 was not We didn't give as much guidance as perhaps we would need to. This comes up only if there's more than one offense. Because if there's only a single offense, it can't be worse than murder. So if you had the worst kid in the world, and Officer D'Amato had been shot a few inches from where he was and had died, we would only say 15 years to life.
Yes.
So when we speak about extraordinary circumstances, isn't the first issue as to whether the other crimes added to the non-murder crime even arguably might justify a sentence greater than 15 years minimum? And then, once you make that determination, then you decide whether the Miller factors should mitigate that?
You could say that was the problem, although this court had used the plural in talking about offenses, in particular to Mr. Perez and to others who are facing Miller hearings. You remanded for a Miller hearing, knowing that there's a possibility that someone convicted of non-murder offenses, plural, still had a sentence longer than had he committed first-degree murder. But yes, I'm certainly am not saying that there was any intentional, abuse of discretion. I think that there should be some more education and for the judges to understand that it's not an abnormal brain. The adolescent brain is not abnormal. The adolescent brain is normative.
I know the adolescent brain is different than the adult brain, but isn't there a difference still between an adolescent brain that commits crimes and an adolescent brain that doesn't?
Well,
and doesn't that have to be a factor in this?
You say that, but in one of the articles, they did a study of people who never had been convicted of a crime, the average people, and asked them, what did they do as juveniles? And what they found was it's unusual not to have committed a crime. And I'm not talking
not
about
within the
armed
scope
robbery.
of armed robbery and
Of
attempted
course not,
murder.
but really, and I think a lot of adults will sort of brag about what they did as teenagers, not realizing that. But so I disagree that it's, yes, armed robbery is different, but then Perez was different. He was a different 17-year-old.
All right, thank you.
Thank you.
Ms. Ferris?
Good morning, may it please the court. My name is Elizabeth Dunphy Ferris. I'm legal counsel to the district attorney for the Hampden District, and with me today is Catherine McMahon, who is an assistant district attorney for Hampden County. It's the Commonwealth's position, first off, that the motion judge correctly applied the Miller factors as this court directed him to do upon remand. And then I would like to address the issues that my sister brings up for the first time on appeal in her first brief, and then for the first time on appeal in her reply brief, and that deals with the burden of proof.
Yeah, can we
issues.
can we start? If you look at the sentence,
Yes, Your Honor.
5 years for the armed robbery of the couple picking up their kid at the train station, which
Yes, Your
involved
Honor.
the stealing of a purse, I believe, or stealing of wallets.
A wallet and a purse.
Right. Then
With
5
the show
years.
of a handgun.
Sorry.
With the show of a
Right,
handgun.
it's an armed robbery, there's no question. Then there's the armed robbery of the jacket, which is 5 years on and after.
Yes, with the pointing of a handgun.
And then there's the two offenses, armed assault with intent to rob and A and B DW. Both of them concern the shooting and robbery of Officer D'Amato, the attempted robbery of Officer D'Amato.
Yes, Your Honor.
Okay, but that's 17 and a half years. If Officer D'Amato tragically had died, as opposed to having been very seriously wounded, and no one disputes the seriousness of this crime, it would have been felony murder. He would have gotten only 15 years for that. 15 years minimum, 15 years to life. So how can he get 17 and a half years minimum for a crime that, if it had resulted in death, would have been a 15-year minimum?
He, for his armed assault with intent to rob and his assault and battery by means of a dangerous weapon, The judge factored in the two different crimes
Right, you get
that were
7.5 to 10,
committed.
and they got 10 years and 10 years, or 9 and 364 days to 10 years. But if he had died, we would have merged them, and it would have been
But
felony murder.
He did not die, and merger did not come
I
into play, and
understand,
therefore.
but the question is, how can the judge say that he gets a longer minimum sentence where there was not a death than he would have gotten had there been a death?
Well, he would have gotten a sentence of life.
15 years to life.
He would have gotten a sentence of life
Life.
in 1992.
Right.
He would have been parole eligible in 15 years because once Dachenko was decided by this court, there was no other procedure or other term of years for which the defendant could be parole eligible under a life sentence. It's our argument that a life sentence is longer than 17 and a half years because it's a life
But
sentence.
all we're speaking about here is the opportunity for parole. There's no doubt that he could have given a life sentence. He could have told it up. I don't know what the maximum is for armed assault with intent to rob.
It's 20 years, Your Honor.
20 years. So he could have gotten, and I guess AMDW is another 10?
It's 10, so he
So
could have gotten
he could have
30
gotten
for
30,
those two.
but Perez 1 speaks about a sentence treating, for parole purposes. So this is only about when do you get a chance for the parole board to say, we will release you? And I don't understand how the parole board, because he lived, can't review it for 17 and a half years, when if he had died, it could have reviewed it after 15 years.
The parole, depending upon how the judge imposed the sentences in this case, the judge imposed the life sentence from and after the sentences of the first two crimes. Therefore, his parole eligibility would have been after he served the sentences on the first two crimes, and then the 15 years on the crimes for Officer D'Amato. It is only when the lead sentence is the life sentence, and there are consecutive sentences, that parole eligibility comes at 15 years. It's easy to look in hindsight as to taking taking the sentencing scheme as imposed by Judge McDonald and suggesting this is what he meant by parole eligibility. Actually, Judge McDonald said, I don't think you should see the parole board for 27 and a half years. That was his intent in sentencing. The motion judge then looked at the Miller factors and the crimes, as was required by this court's remand, and said, I believe a sentence of 15 years is reasonable, and I don't believe anyone would say it's not reasonable for the actions in relation to Officer D'Amato. He then looked at the other crimes, and he said, I believe a sentence greater than what the judge gave would have been reasonable, and he uses the numbers of 6 years. And then he says, if I add 15 to the 12, that's 27. So therefore, and totally looking at the sentencing scheme, he suggests that it is a constitutional sentence and it's not infirm. And that's after looking at the Miller factors. So we didn't have a death.
But the nature, I understand, the nature of Perez is that there's a conclusive presumption that when you have more than one crime, it only deals with where there's more than one crime. It is a conclusive presumption unless there are extraordinary circumstances to warrant a sentence. And so I'm trying to understand, it seems to me that the extraordinary circumstances would have to focus on the severity of the first two robberies, because apart from that, are you saying there could be extraordinary circumstances to give more than 15 years parole eligibility? So if you were to conjure the attempted armed robbery and shooting into two crimes? Is that what you're saying?
No, I'm saying that this court did not say it was multiple offenses only when
Well, no,
Perez
it does.
is implied.
A juvenile's aggregate sentence for non-murder offenses with parole, it focuses only on the issue of more, we dealt with this case, so I mean, it deals only when you're basically having more than one crime which are bunched together. That's where the issue is raised.
I believe it's raised as well if he received 20 years on the armed assault with intent to murder,
So
attempt to rob.
your view is that if there had been only the events with regard to Officer D'Amato, that it would have justified a sentence more than felony murder?
It's hard to factor those in, Your Honor, because I would say yes, but it's hard for a judge to factor those in because a judge is looking at two separate crimes with two separate sentencing schemes. The armed assault with intent to rob is a 20-year felony. Has a maximum sentence 10 years greater
I understand
than
that,
the bodily
but if
injury.
he had died, it would be felony murder, and you wouldn't be separate. They would be the underlying felony would be merged into the, unless you want to say, oh, there's an armed robbery, and then there's another underlying felony, and we're going to sentence him on both, and we're going to give him more than 15 years for the same event.
I would suggest to this court respectfully that in arguing sentencing and in arguing circumstances, which is done at a Miller hearing, which is a sentencing hearing, the aggravating factor of the pain and suffering of the victim in relation to an assault and battery is a extraordinary circumstance.
If that's the case, then we might as well get rid of Perez 1, because it means if extraordinary circumstances are going to be pain and suffering, there's almost always going to be
Counsel,
that. I mean, pain and suffering worse than death, because death would be 15 years to life. I mean, the premise of Perez 1 is that you're imposing a sentence where the parole board cannot release you, that the person who kills somebody can be released before this person, and that to do that, there has to be something extraordinary. So you're saying that the pain and suffering of the victim is sufficient by itself to be an extraordinary circumstance?
No, Your Honor. It's a weighing of all the factors. And it's a weighing of, this court has required a judge to weigh the Miller factors, so it weighs the other factors that are attendant to a juvenile, as well as the circumstances. Was he a joint venture as opposed to a principal? That would be a factor. Did he have any mental illness that affected his ability to think that night? That would be a factor. There are additional factors that the judge weighs every day in relation to sentencing. Those are not obviated because Perez 1 says that a judge must add these additional factors attendant to youth. It just says that a judge must be careful, must weigh these additional factors, and then must find that whatever evidence exists on the other factors by which he rules his sentence is constitutionally firm, is and should be extraordinary. So it's not the usual sentence.
Okay, but I
But when
understand.
you have,
Do you agree that there are kids with worse backgrounds and histories than Mr. Perez? That we often get cases of such in which you have kids with a substantial history of prior violence who don't have the kind of background that this kid had. I mean, to have no criminal record up until that point, that's
he had interaction
unusual.
with the criminal justice system, he had no record. The sentencing judge said he wasn't going to determine or utilize the diversion program for which the defendant was in juvenile court for. But yes, I do not suggest that this sentence is based on the defendant's prior criminal history.
Counsel, may I ask you a question? With regard to the constitutional presumption that was discussed in Perez, is it your understanding that that case said that there could never be a constitutional sentence for somebody that's longer than somebody who committed a first-degree murder?
No, I think it's absolutely
And
the opposite.
do you think that there is, within the sentencing range and these requirements for a Miller hearing, if the legislature sees fit to change the sentencing scheme or the sentencing structure for juveniles, that that's more of a proper forum than the judiciary?
Yes, Your Honor. My sister doesn't raise it in regards to, doesn't raise the issue in regards to the consecutive nature. In thinking about this case, if I had gone to trial separately on each of these charges, we wouldn't be here, because none of the sentences are in and of themselves constitutionally infirm. It's when they are done in the aggregate. If I had done separate trials, if the defendant had won the opposition to joinder of these offenses, and there had been separate trials, we wouldn't be here.
Can I ask you about the standard of review
Yes, Your Honor.
What do you say it should be
In
for us?
Perez 1, this court said that the standard of review was abuse of discretion. We don't believe that there's any difference than what this court said in Perez 1 of abuse of discretion. And in utilizing that abuse of discretion, it's not whether this court would make a different decision, it's whether the judge relied upon the factors and whether he weighted them in his decision. It's clear that Judge Ford took the information that was provided to him. I do wish to suggest to the court that when my sister suggests de novo review, there are some school psychological records that were attendant to the probation department's report, which were provided to the sentencing judge and were within the probation department's file. They were not provided to the parties. The defendant gave them to the probation department so that the probation department could make its report. Of particular importance there is a 1999 report, which Dr. Deidre Sands testifies to, talks about in her report, and which I suggest, my sister suggesting that he had no problem behaviorally previously is not correct. There were prior behavioral problems. There were no prior criminal offenses.
We have the unusual circumstance in this case where Judge Ford conducted the trial of the co-defendant.
Correct, Your Honor.
And said I was familiar with the case from that. Does that, how do we take that into account as far as our review?
I think it's unique, but I think to the extent that the judge utilized the victim impact statements, the judge had the ability to see the victims testify and to see them present their impact statements in the case of Mr. Abrante. I think it also important for this court to look at the issue of proportionality in relation to the adult co-defendant in this case. The adult co-defendant in this case, while only a joint venturer, clearly a man that deserved every day that he got for the sentences that were imposed. He was a joint venturer, but he received life plus 18 years, and
But
therefore
he had a huge record, too, so it was
he
going to
had
be...
one. Your Honor, if I may, he had one set of offenses when he was 17 years old.
Oh, that's all? Okay.
He had 3 robberies when he was 17 years old, for
Where,
which he received
where does
death.
Perez 1 say that we review it by abuse of discretion?
In the beginning, it's in the beginning of the decision, Your Honor. I don't know the exact page, but it's,
I mean, I think you're wrong, but how can it possibly be an abuse of discretion when it's a constitutional determination under Article 26? Isn't the standard always we examine the subsidiary facts and accept them unless clearly erroneous, but then we apply those facts to the constitutional standard de novo, as we do in every constitutional case?
that's not what Perez says in abuse of discretion, Your Honor, in reviewing a sentence for constitutional
Again, I
infirmity.
question whether you're right about that, but but even if it does, were we not wrong? Isn't it a constitutional determination under Article 26 that we must review as to whether or not, it's not as if some judges can, we don't generally do abuse of discretion when we're examining whether there's a constitutional violation.
This court in Perez 1 indicated that if the constitutional nature of it was that the judge needed to, before a sentence could be imposed that was lengthier than a sentence for parole eligibility of an individual who committed murder, whether it be one or aggregate sentences, must consider the Miller factors.
Right.
Miller was to provide a juvenile defendant a reasonable opportunity to see the parole board. And therefore, it's our argument that once the judge applied the Miller factors, while this court certainly can look at the way in which the motion judge applied the Miller factors, it is not a de novo review.
Isn't it de
There are
novo?
certain
Isn't it de novo as to whether there are extraordinary circumstances that warrant a sentence treating the juvenile defendant more harshly for parole purposes than a juvenile convicted of murder? Isn't that the Article 26 standard?
I don't believe that that's what was sent to the motion judge. So I don't believe it is the standard, Your Honor. I don't think it's de novo review.
I'm reading from Perez 1. I mean, Perez 1 at the very end says that The option remains open to a sentencing judge in an appropriate case after weighing the factors considered in the, and when Article 26 requirements as articulated here are met. This is an Article 26 issue. It's a constitutional issue.
Yes, the judge, but once the judge the judge weighs it the judge weighs the factors differently. There was no indication to the motion judge here that there should be a burden of proof, that the burden of proof is on the Commonwealth, that this is an evidentiary hearing. It was not an evidentiary hearing. The clerk's docket is clear that the judge said on October 4th of 2017 that he was going to hold a non-evidentiary hearing and hear arguments of counsel, and that counsel could provide whatever documentation they wished. There was no agreement as to which documentation was going to be applied. There certainly were factual determinations to be made by the judge. In particular, I would point the court to the report of Dr. Dieter Sands. She was subject to cross-examination, but not all of her report was allowed into evidence. There was a motion in limine by the Commonwealth, which was successful, in relation to much of what was in Dr. Dieter Sands' report. So the jury heard the conclusions in relation to how that affected the defendant's state of mind that day. But her report was then put in for sentencing purposes. I didn't object. My sister says I didn't object. I don't think we had grounds to object. Under Rule 28, the defendant has the ability to provide mitigating information.
Right,
But
you're relying on the beginning of our discussion. We review the denial of a motion brought under Massachusetts Rule 30A for abuse of discretion. Under that standard, the issue is whether the judge's decision resulted from a clear error of judgment in weighing the factors relevant to the decision, such that the decision falls outside the range of reasonable alternatives.
Yes, Your Honor, because this is a collateral attack to the defendant's sentence. It was sent to remand because the court determined that without looking at the Miller factors, which is the fault of what this court found from the sentencing judge, that the Miller factors needed to be factored into a sentencing for this defendant. And so therefore, if I may, just for a brief moment, and I see that I'm out of time, but in relation to credibility, Dr. Dieter Sands suggests that the defendant was totally incapable to any of the demands of his uncle, partly because the defendant said that he believed his uncle had supernatural powers. Specifically, Judge Ford rejects that as being a credible piece of evidence. And so therefore, the mere fact that the defendant presented this report and the report of the probation department and the report of Dr. Sherry, which is an aid in sentencing, do not suggest that the court has to accept the facts that are in there. There was a weighing by the judge in relation to those facts. And it's the Commonwealth's position that in that weighing, which is done for every types of sentencing, that there is no constitutional protection to a juvenile to have sentencing done differently as long as the Miller factors are weighed.
Well,
This court may
it says
review it.
something a little bit more than that. I want to go to the way I was reformulating perhaps Ms. Caddick's point. What has to, you don't just look at this as you would any other sentence and touch all the bases of the Miller factors. What has to happen is the Commonwealth touching all the bases, the judge touches all the bases of the Miller factors, and then there's a burden to show that there's extraordinary circumstances to rebut the presumption of a disproportionate sentence. At the end of the opinion, Judge Ford concludes that the sentence imposed by Judge McDonald was thoughtful, and we read the transcript. He gave this a lot of thought, measured and consistent with both the goals of sentencing and the ends of justice. I see no need for resentencing. The issue that I'm asking about is, well, that all sounds reasonable, but what happened in Perez is the Commonwealth has to meet its burden to show that there are extraordinary circumstances that rebut the presumption of a disproportionate sentence, not just that all the Miller factors were thoughtfully considered and that the sentence is reasonable. If that's what's going on, did Judge Ford do that?
Yes, Your Honor, and I would suggest that page 9 of his opinion suggests that he weighed factors of not that it was not the only crime that the defendant committed on the night in question. He robbed 3 other people in 2 separate and distinct criminal episodes, and then he goes into the trauma of those victims in relation to factors. He said each of these robberies carried a 5-year minimum mandatory sentence because they were committed with a firearm. That's right before the quote that
I
Your Honor.
understand, and he did do that. And then he also says that Judge McDonald felt that consecutive sentences were appropriate with respect to the impact of the crime on each individual victim. What I'm saying is that it's a question, it's not an answer, does Perez require more than that and say, okay, it was appropriate, yes, all the Miller factors, I've considered them, and I consider that this sentence meets the goals of sentencing of the ends of justice, I see no need for resentencing. Is that enough, or does the judge have to, after looking at all these Miller factors, explain why the circumstances are extraordinary enough to rebut the presumption of a disproportionate sentence?
I believe Perez 1 does not inform the court, in the lower court, as to the manner in which it writes its opinion. The legislature in Chapter 119, Section 58, for a juvenile justice that must determine whether or not they are going to sentence a youthful offender to a state prison sentence, to a DYS sentence, or to a middle sentence, a split sentence, suggests no burden of proof, but that the judge shall set forth the factors that they considered. It doesn't use the term extraordinary circumstances, but it does suggest that the judge write a memorandum for the purposes of sentencing, and that memorandum shall say what are the factors that the judge considered. In this case, I believe based on 119 Section 58, based on Perez 1, the judge did that. He showed what factors he was considering in relation to Perez, and then he considered all of the sentencing factors and came to the ultimate conclusion. And he says, for the foregoing reasons, I don't think that we can parse out one or another statement of the judge. I think it's for all the reasons that he stated within his memorandum, he weighed them to be that there were extraordinary circumstances. And I think the court can take from his memorandum that he did so, looking at the multiplicity of victims, the use of a firearm. If you look at his comments during the sentencing hearing, he said to counsel for the defendant that if this had been a purse snatching, I may be with you. But it wasn't. It was 3 separate acts of the use of a handgun in a robbery prior to the time that he committed the acts against Officer D'Amato. And so I would suggest to the court that right now Perez 1 does not provide the guidance to the lower court, but that I'm not sure that it's necessary because there is a discretion of a judge in this case to have imposed, and it's actually 5 separate sections. The defendant has a condition of probation when he is released on one of the armed robberies. Therefore, he would face a life sentence. If his parole eligibility and which victim doesn't get a sentence in this case, how would a judge resentence this defendant for parole eligibility at 15 years? It either takes away his discretion to be able to sentence for each of the crimes for which the defendant stands before him, or this court must find that the statute that allows for consecutive sentences when it applies to juveniles is constitutionally infirm. That isn't the way that my sister has phrased the argument for the court, so it hasn't been fully briefed for this court. But we would suggest that Perez 1 was following Miller. The sentencing judge did not, in this case, take into the factors of the defendant's youth and the other Miller factors which are set forth in the Perez decision. It sent it back just like it sent the case back in Costa, and it said, look at those factors and decide whether there are extraordinary circumstances. That's what the judge did in this case. The defendant now tries to put on burdens of proof that are applicable in other states for life without parole sentences for which this state does not allow. a life without parole sentence. And in Pennsylvania, she cites the Batts case in her reply brief. She changes the burden of proof from her first brief to her reply brief, and in the reply brief says it's beyond a reasonable doubt on the Commonwealth in relation to a sentencing hearing. First, they're not evidentiary hearings in Massachusetts. Secondly, in relation to this case, she didn't present that to the lower court. And thirdly, in Pennsylvania, in the Batts case, it can be, Miller factors are used with life without parole, but in the Fost case, which was decided in February of this year, aggregate sentences are not used. Only individual sentences are not used. So if we were in Pennsylvania, that standard would not apply. For all the reasons, Your Honor, I see I'm out of time. The Commonwealth would ask the court and respectfully suggest to the court that the motion judge applied the factors correctly and that the sentences in this case should stand, that there should not be resentencing.
All right, thank you.
Thank you.